Every state has child support guidelines, which are essentially the law and the corresponding formula to determine child support. Every 4 years, a task force is formed to assess and update the guidelines. And in Massachusetts, this has just occurred, with new guidelines having gone into effect October 4th, 2021. Today, a few members of our Turco legal attorney staff discuss some of the most significant and interesting changes to the guidelines. Andrea, get us started with compensation types, how alimony correlates in lower and higher income earners.
More and more often, folks are either being compensated in a different way or actually requesting being compensated in a different way that in prior versions of the guidelines may have been able to keep that income out of the calculation. So we're talking about things like stock options and sort of other incentive pay. So that's now listed specifically as something that can be included in calculating the guidelines. So that was pretty important. They also looked at whether alimony is included in calculating the guidelines. So there's a little bit of disparity in between the Chapter 208, Section 53 that talks about, we won't calculate alimony on any amounts over the income that was used to calculate the child support guidelines in the first place. So the court is able to look more carefully at potentially running alimony before running child support. So including the alimony payments and the child support recipient's income and deducting it from the payor's income, and suggest that perhaps we run it some different ways, that we can actually look at each case on a case-by-case basis to say, how are we allocating all of the money that's available to this family? So that typically happens when there's a single payor, so somebody would have to pay child support and alimony, and it applies less so and differently if one person is paying alimony and the other person is paying child support. And so we sort of have these cross orders. So at least there's more language in there that we can look to help us decide what's fair in each particular case. Another thing that the guidelines have changed is that there were circumstances where really low income folks were paying amounts that didn't really leave them with subsistence levels of income to support themselves. So they've added a few categories that allow, if you're earning less than $249 a week, that the minimums for child support are a little bit lower. And then there's a calculation for some higher amounts. They also raised the maximum, which is in the prior version of the guidelines. We only looked at combined income of the two parents, combined income that was over $250,000. And they've raised that to $400,000, in part because that number hadn't changed for 12 years. So looking at what it costs to raise children in Massachusetts and what the incomes are for folks in Massachusetts versus some other places in the country, it seemed to make sense to raise that. So what that does mean is we look at child support on the first $400,000 of combined income of the parents. And then whatever that number is sort of the presumed minimum child support order. We can then also look at the amounts over $400,000. And if you're fortunate enough to be in that category, it wouldn't be appropriate just to rerun the child support guidelines on the amounts over $400,000 because that really recaptures a higher percentage. So, if you have $100,000 of income, the percentage of child support is actually a little bit greater of your income than it is at the higher levels. So what they've said is for anything over $400,000, if we're looking at additional child support, because again, we're talking about a presumptive minimum at $400,000. So if we're looking at something over that, then not just rerunning it, but it really should be at the maximum percentage, which at that $400,000 level, which is about 10%. Finally, then there's also that interplay with alimony. Talked about that a little bit. But there were some circumstances where someone who had no children and was only going to be receiving alimony would actually get more than someone who had children, so that the child support number would actually come out lower. And so now you have somebody who might have two children in a home and is receiving less money than if they were single and only getting alimony. So the court, again, tries to look at that now. And there was a case that came out, Calvin C. versus Amelia A. And so they specifically refer to that case for folks to look at in order to determine how we are, combining the alimony and child support aspects.
So if any of you were able to sit in on the Mass Bar Association's family law program the other day, but the first section of the day was talking about the child support guidelines and amounts above the 400,000 figure. what I found interesting, because we've kind of grappled with like what percentage do we use above the threshold amount for support, and it's like been a subject of negotiation over the years in all of our cases. But the way they suggested doing it in the meeting in the program the other day was taking that 10% figure, but then dividing that further based on the percentage of income. So if one party's income was 40% and the other party's income was 60%, and the payor's 60% of the income, for instance, instead of using 10%, you would use 6%. Did anybody else catch that?
I did. Yes, I actually attended that too, Damien, and it was hugely instructive. In fact, obviously, child support is one of the most contested areas and one of the main reasons people find themselves returning to court. And they may not realize that they're paying their attorneys more to argue about vague areas of the law, such as what's the percentage above 250,000. Some attorneys would run it one way, some attorneys would run it another. So it's very instructive that the task force has now told us what to do, essentially. And that furthermore, that it's not fair if, the payor's percentage of income is only 6%, it's not fair for him or her to be paying 10% on that. The actual amount they should be paying above 400,000 is 6%. So it's instructive for us all, and it saves people time and money in the end. But I think it's going to take us a little time working with the worksheet and the different tables with the percentages to actually see how it plays out.
And now, Maureen, how about the child multiplier? How has that changed?
The task force retained a separate independent group, economic group, that researched economic data and policy considerations as far as what it costs to actually raise children and what it costs to raise one child versus two children versus three children. The prior incremental increases had been 1.25, 1.38, 1.45, and 1.48 for 2 children, 3 children, 4 children, and 5 children, respectively. The independent group, I think it was the Brattle group, came back and reported that the actual cost is more than that. So the task force recommended, and these guidelines adopted an increase for more than one child. So that has now been increased to 1.4 for 2 children, 1.68 for 3 children, 1.85 for 4 children, and 1.94 for 5 children. So in practical speaking, what that means is that if you get $100 if you have one child, if you have 2 children, you'll receive $140. So the guidelines run that automatically. And then of course, it continues to incorporate, I think someone else is speaking about, children over 18 and children under 18. But it did increase that. And for raising children, I think it's going to reflect the actual cost of what people are spending. And so I think it was a good change and well received by the bar.
Thanks, Maureen. Now, Jess, tell us how childcare costs and healthcare coverage have changed under the new guidelines.
2 big changes in the 2021 child support guidelines in terms of childcare costs and healthcare coverage. Under the old guidelines, there was a 15% cap on the cost sharing for both childcare costs and healthcare coverage. So what was happening was a lot of parents were actually missing out on the credit that they should have been receiving for actual payments made. Under the new guidelines, that 15% cap is eliminated, but how childcare costs and healthcare coverage are treated are a little bit different under the new guidelines. So we're going to start with the childcare costs. Under the old guidelines, the parent who paid the childcare costs would simply deduct the amount that they paid from their gross income. Under the new guidelines, the task force recognized that parents really should be sharing in these costs in proportion to their respective income, up to an amount of $355 per child per week. Now, this doesn't mean the parents have to pay $355 per week for childcare. It's simply a cap. So how that plays out in real life is basically if both parents are earning the same amount equal, they're 50-50 contributors, they would each pay 50% of the childcare costs. In a scenario where one parent is earning 20% of the combined total income and the other parent is earning 80%, again, they'd be paying 20% of childcare and 80% of childcare. So the next question that would come up is, well, what happens if you have more than one child? And the guideline simply makes a calculation based on the number of children times that $355 per week. The second issue, as I mentioned, is in terms of healthcare coverage. Again, the new guidelines eliminated that 15% cap. But the difference here is that the new guidelines do not include a cost sharing provision like the child care cost provision does. In this area, it simply allows the parent that's paying for the healthcare coverage to deduct the amount that they are paying from their gross income.
Thanks, Jess. Now, in Massachusetts, child support can go until the children reach age 23, and the parents may be ordered to contribute to their college or other post-secondary education costs. So, Kristen, fill us in on these issues under the updated guidelines.
So the court has the discretion to either order or decline to order child support for children over the age of 18. They almost always order it, I find. And if they are going to order it for children over 18, it's factored into the guidelines. One of the changes they recommended is in the 2018 guidelines, the court was to consider the available resources of the parents. And they changed that to say the court will consider the available resources to each parent. So you're considering the resources to each parent individually instead of collectively. So they just wanted to emphasize that they're evaluating each parent's resources individually. The other change was with respect to contribution to post-secondary education expenses, so college expenses, similar to the changes to the language for child support for children between ages 18 and 23. In terms of contributions to post-secondary education, they wanted to change the language to consider the available resources of each parent, again, instead of the parents collectively. And they felt that it was important to emphasize that the court should consider whether one person saved and the other person didn't. So you shouldn't penalize the parent who's been saving all these years and has this income available because they set it aside. They shouldn't be penalized for doing that. So they wanted to make it clear that the court can consider both parents individually when making this order. And they kept the cap. Essentially, the cap is 50% of the cost of an undergraduate in-state college education at UMass Amherst. And so they kept that the same. That was it. That was a small change.
Thanks, Kristen. Now, the guidelines give us a presumptive figure of child support, but the judge may deviate from that figure when appropriate. Maureen, fill us in on how deviation works under the 2021 guidelines.
As far as deviation, Section 4 has always addressed the deviations from the child support guidelines. The guidelines are the presumptive amount that the court is to order, but there are deviation factors, as we've all been talking about today. The task force again emphasized that there are certain circumstances where setting a child support order at even $0 may be appropriate. It emphasized that sometimes that can be and there are several factors listed, but it specifically addressed and clarified that a parent who has extraordinary travel or other expenses relating to parenting time. So this would be the parent who has to travel from out of state for parenting time. That may be a deviation factor. Another thing that is addressed is a parent who has extraordinary childcare costs for the children covered by the order. That may be for a special needs child or a child who's very ill, something like that. So this is something that is not typical, would be extraordinary. Another thing which is new, and there's a special box that's automatically checked when the guidelines compute that this is triggered is whenever application of the guidelines requires a payor to pay the recipient more than 40% of the payer's available income, there's a little box that gets sort of checked, and it's what they call a rebuttable presumption that it's a substantial hardship, which would justify a deviation from the guidelines. And that doesn't necessarily mean that the payer's child support payment would go all the way to zero. But if the payor is paying above 40% of his or her available income, that would be a rebuttable presumption that it's a substantial hardship to him or her, and that amount should go down.
Thanks, Maureen, and thanks, team. There were several other changes under the guidelines this time around, and if you want to understand them all, read them. Read the guidelines and read the comments. They do a great job of explaining what's changed and why. The guidelines and the comments are found on our website and on mass.gov. Otherwise, we'll see you next time.